Welcome to today's program, USPTO Hour, Congressional Inquiries regarding patents topics. I am Sean Hunter, the Director of the Office of Patent Stakeholder Experience here at the United States Patent and Trademark Office. The USPTO recently unveiled 7 patents business unit priorities, which are represented by the acronym INVENTS. Each of those priorities represents the agency's commitment to strengthen the U.S. patent system, enable innovators to secure patent protection for their inventions, and provide durable patent rights that make the United States intellectual property system the best in the world. With that, it is my pleasure to introduce today's speakers. Tamara Foley, Acting Director of the Office of Governmental Affairs, or OGA, Brian Hanlon, Assistant Commissioner for Patents, and Daniel Sullivan, Director, Technology Center 1600. Tammy Foley is the Acting Director of the Office of Governmental Affairs here at the USPTO. Ms. Foley manages a team responsible for working within and across government to support the mission of the USPTO by monitoring congressional activity, analyzing legislative and policy proposals related to the USPTO and intellectual property issues, and facilitating communications with federal agencies as well as state and local government entities on IP policy and activities. Ms. Foley has been with the Office of Governmental Affairs since 2017. Prior to serving as acting director, Ms. Foley served as deputy director and as an attorney advisor for the Office of Governmental Affairs. Ms. Foley has worked on numerous legislative and policy proposals related to patents, trademarks, copyrights, trade secrets, and USPTO operations. She has also provided support to agency executives who have been called to testify before Congress. Brian Hanlon serves as Assistant Commissioner for Patents in the Patents Business Unit. In this role, he is an authority on patent laws, rules, and examining practice and procedure, and provides administrative oversight and direction for the activities of the Office of Petitions, Office of Patent Legal Administration, Office of Patent Quality Assurance, the Central Reexamination Unit, and the Manual of Patent Examining Procedure staff. Before becoming an assistant commissioner, he held the position of director of the Office of Patent Legal Administration. He has also served as the Director of Strategic Planning and Management Council for Undersecretary and Director John Dudas, and served as a special advisor and acting chief of staff for Undersecretary and Director David Capos. Mr. Hanlon began his career as a patent examiner at the USPTO in what used to be called Group 3300, which is now TC 3700. Mr. Hanlon has been involved in numerous patent-related rulemakings, including implementing the Patent Law Treaty and the patent examination-related provisions of the Leahy-Smith America Invents Act. Mr. Hanlon was also a shareholder at the law firm of Banner & Witkoff, where his practice focused on patent prosecution and client counseling on issues relating to both procurement and enforcement of utility and design patents. Mr. Hanlon holds a bachelor's in mechanical engineering with honors from Worcester Polytechnic Institute and a JD magna cum laude from the Catholic University of America, Columbus School of Law. Mr. Daniel Sullivan is the Director of Technology Center 1600 and provides oversight for patent examination operations in the areas of biotechnology, chemicals, and pharmaceuticals. Dan joined the USPTO in 2002 to examine in the biotechnology and pharmaceutical art areas. In 2008, he was promoted to Supervisory Patent Examiner, and in 2014, he was promoted to Technology Center Director. Before joining the USPTO, Dr. Sullivan earned a BA in Biology and a PhD in Pharmacology from the University of Missouri, Columbia, and worked as a research scientist at the National Institutes of Health. Director Sullivan provided oversight, implementation, and analysis of the DSMR pilot. With that, it is my pleasure to turn it over to Tammy.
Thank you, Sean, and thank you to everyone joining us this afternoon. The Office of Governmental Affairs, or OGA, is a small but mighty team made up mostly of career employees and a political employee. The team includes a deputy director, attorney advisors, congressional affairs specialists, and executive support. And we are led by the Director of Governmental Affairs, who is a political appointee. OGA sits within the Office of the Undersecretary, and the OGA Director reports directly to the Undersecretary and the Director of the USPTO. Our office works within and across government to support the mission of the USPTO in a variety of ways, as laid out here in this slide. We work closely with the USPTO director and leadership, as well as the Department of Commerce and the administration, in formulating legislative and policy proposals that influence intellectual property policy and in analyzing external proposals that impact the agency or IP policy. We serve as a conduit of information between the USPTO, Congress, and external stakeholders on agency matters and policy. We support agency executives who are called upon to testify at congressional hearings by preparing testimony and briefing materials. And we facilitate communications between USPTO and other federal agencies, as well as state and local government entities to help coordinate IP policy and activities. As I mentioned, we work closely with the USPTO director and USPTO leadership, as well as the Department of Commerce and the administration in formulating legislative and policy proposals that influence intellectual property policy and in analyzing external proposals that impact the agency or IP policy. The formulation of legislative and policy proposals is driven by the priorities of the USPTO director, as well as the Secretary of Commerce and the administration's priorities. Each new USPTO director and administration brings a different set of priorities that drive their legislative and policy proposals. As for external proposals that impact the agency or IP policy, the USPTO provides technical drafting assistance on those matters. This analysis is done in coordination with the subject matter experts within the USPTO, and they often touch upon all areas of intellectual property, including patents, trademarks, copyright, trade secrets, international IP issues, and enforcement of IP, as well as legislation or policy proposals that affect the operation of the USPTO. The Office of Governmental Affairs coordinates clearance of this technical drafting assistance through the Department of Commerce. These requests often come through the interagency legislative coordination and clearance process, as specified in OMB Circular A19. These legislative referral memoranda, LRMs, are the primary way that the Office of Management and Budget coordinates and clears legislative proposals, congressional testimony and reports, etc., in order to ensure consistency and to ensure that the administration speaks with one voice. OGA also actively monitors legislative developments in Congress, including any legislative proposals that may have USPTO and/or IP equities, as well as any that may have an impact on USPTO operations. OGA also supports agency executives in preparing to testify at congressional hearings. This can include helping to prepare testimony and briefing materials for their hearings and arranging mock hearings. Such hearings can include oversight by congressional committees, as well as hearings that touch upon specific IP issues. For the USPTO, hearings are often before the Senate Judiciary Subcommittee on Intellectual Property and the House Judiciary Subcommittee on the Courts, Intellectual Property, Artificial Intelligence, and the Internet, which are our committee and subcommittees of jurisdiction. I'll note that there have also been instances where USPTO executives have been called to testify before other congressional committees. In all instances, however, the Office of Governmental Affairs will work closely with these executives to help prepare them for their hearing. OGA also helps facilitate communication between the USPTO and other federal agencies, as well as between the USPTO and state and local governments to help coordinate IP policy and activities. Much of OGA's work with state and local governments is done in close coordination with our colleagues at the USPTO's regional offices. OGA also facilitates communication between our office and other agencies within the federal government, particularly as it relates to IP issues and our USPTO equities that may arise. OGA serves as a conduit of information between the USPTO, Congress, and external stakeholders on agency matters and policy. For members of Congress and their staff, OGA seeks to be the primary resource for them on any and everything IP and USPTO related. If they have any questions about IP or the USPTO, we hope that their first call will be to the Office of Governmental Affairs at the USPTO. Information with Congress is shared in a variety of ways, from congressional briefings on specific IP issues to general background on IP more broadly or on USPTO issues. OGA also coordinates responses to congressional inquiries, including congressional letters on specific issues or policies of the USPTO or the administration, as well as congressional constituent letters that seek to provide USPTO information to a member's constituents. OGA also regularly monitors hearings across congressional committees, and not just those in the Senate and House Judiciary Committees that have jurisdiction over IP issues. This information is shared with USPTO leadership and the relevant subject matters within USPTO so that they may stay abreast of developments in Congress as well. OGA also helps with statutorily required reports and studies, as well as those requested by individual members of Congress. For example, in the last couple of years, the USPTO issued 3 reports that were required by the Unleashing American Innovators Act. The first was on a study of the USPTO's patent pro bono program, a second report on the USPTO's statutorily required fee study, and lastly, a report on USPTO's study on the need for additional regional offices. Similarly, in 2019, the USPTO issued the Success Act report, as required by the similarly named statute. USPTO can, at times, also conduct studies and issue reports at the request of individual members of Congress. For example, in 2022, the USPTO issued a report summarizing collected views on the state of patent subject matter eligibility that was requested by individual members of Congress. Inquiries from members of Congress can also lead to other initiatives at the USPTO, including pilot programs. One such program will be discussed in greater detail by Dan and Brian during their presentation on the Deferred Subject Matter Eligibility Response Pilot Program. OGA also regularly engages with external stakeholders on USPTO and IP issues. For the USPTO, its external stakeholders are essential and key to the continued success of the USPTO and the IP system in general. As the primary users of the system, they offer important perspectives and information that can help the USPTO improve our operations and adjust where needed. They can also help provide much-needed real-world information as users of the IP system. Thank you for your time and allowing us to share what we do with you. The USPTO is an amazing agency made of dedicated and hardworking federal employees that are focused on the important mission of helping inventors and entrepreneurs protect their intellectual property. And I know that I personally, along with my team, are excited to be a part of this great place. I'm now going to turn it over to Brian and Dan so they can tell you about the pilot program that the USPTO initiated at the request of members of Congress.
Thank you, Tammy. So I'd like to talk about the Deferred Subject Matter Eligibility Response Pilot Program. I'm going to be doing this, as Tammy said, with Dan Sullivan. He is going to be handling the data portions of it and the results of it as being the executive lead of this program. He is intimately familiar with all of that. So I'm going to talk a little bit about what we did in developing the program and what we went through with applicants as they participated in the program, and then I'll turn it over to Dan. So the pilot was initiated in response to a letter that we received from Senators Tillis and Cotton. The senators asked us to look into, explore putting in a pilot that would apply a sequenced approach to patent examination. So that would be an approach where we would do the rejections and the prosecution for 112 issues, 102 issues, 103 issues. And then after that, we would approach the issues for 101, and then we would handle the 101 or subject matter eligibility issues. But first, we would take care of all of the other issues in the application. Using such an approach would give applicants the opportunity to amend their claims to overcome the 102, say the 103 rejections. And by the amendments that are made to the claims could also obviate the need for any 101 rejection. It may be something where the issue that was at hand was taken care of because applicant had to respond to a 112 rejection in the case and make something more definite. So the approach was really to test that and see if that was viable and if it assisted the agency and made us more effective and efficient. So the other thing is it would also save applicants time and effort and money because, as I mentioned, the amended claims might eliminate the need for any type of a 101 eligibility rejection, so then applicants wouldn't be required to provide an amendment for that or to spend the monies to prosecute such a rejection. So in response to the request, in January of 2022, we announced this pilot program. It's commonly referred to as DSMR. We like to have fun names for the programs that we put out here at the PTO. So in this pilot program, you'll hear as I go through it, it's not exactly what the senators initially approached us with, but we worked with their offices and modified it slightly, as you'll be able to see during the presentation, so that we thought we could meet our statutory obligations and provide applicants the information that they needed while still testing that sequenced examination that the senators were asking us to do. So February of 22, we announced an invitation period where applicants were invited to participate in the DSMR pilot. This included opportunities for the examiner to identify the applications that would qualify for the pilot. All of the information about what type of applications would be part of the pilot were set forth in the Federal Register notice mentioned in the first bullet that was issued in January. So the difference that we had was from what had been asked of us was in the first office action, we did include the subject matter eligibility rejection. So if there was a 101 issue in the case, we identified that in the first office action along with any other issues we saw in the first office action. This way, applicant was on notice of the 101 issues that they may be facing, and they might have a better understanding of the totality of effort that was needed to overcome the rejections of the positions of the PTO with respect to the application. The participants of this pilot were still able to not respond to the 101 rejections, the subject matter eligibility rejections, but instead could defer their responses till later in prosecution, after the other rejections were concluded or until we got to a certain point during prosecution that we'll talk about later. In this pilot, applicants were still required to respond to all non-subject matter eligibility rejections. So if there was a 102, 103, they had to respond to that. If there were objections to the claims, they had to respond to those. It didn't give them a pass for that. It just deferred the need to deal with 101 rejections. And so then the USPTO evaluated the results of this, and Dan will talk about that when he goes through his slides. So how we did this, we talked to examiners and asked for volunteer examiners. And one of the reasons why we asked for volunteers was because this was something very different than what examiners normally did. Normally we have what we call the compact prosecution, but we would put everything in your first office action, all your rejections, objections, and you would continue to prosecute that throughout the application's prosecution cycle. However, here, as I said, we're going to allow them to not respond to the 101 rejections until later in the prosecution life. So from that standpoint, it was a little bit different than what examiners were used to, so we asked if people wanted to volunteer, and we had a strong response from examiners. But the applications had to meet the criteria mentioned in the Federal Register notice, as I talked about before, and that is that when you looked at the claims of the application, there had to have a subject matter eligibility issue as well as prior art issues. No one claim needed to have both, but the application claims had to have both. So the application had to have both a 101 issue and a, say, 102 issue, 103 issue. That way we could test this. So, as you can see here, when the examiners prepared their office actions, they identified that at least one subject matter eligibility rejection. They did the non-subject matter eligibility rejection, and they also included an invitation in their office action. It was a form paragraph that was put in that said, your application meets the criteria set forth in the notice. Would you like to participate in this pilot program? We had some folks that came back and said, yes, they would like to participate. But we required them to formally respond so that we knew that they wanted to participate. We had a number of people that did not respond, that did not take the invitation, and all of those who chose not to participate, who did not accept our invitation, in their next response to the initial office action, they were required to respond to everything. So they had to respond to the subject matter eligibility rejections. They had to respond to the, say, prior art rejections, any objections to the claims, etc. However, the people who joined the pilot were not required to respond to the eligibility rejections. Instead, their eligibility responses were deferred until final disposition of the application, which final disposition, the earliest of, allowance, final office action, notice of appeal, abandonment, so forth. Those are definitions of disposition. So they could wait until they found that the claims were otherwise allowable, and then they had to address the subject matter eligibility rejection. Thereafter final responses or appeals, though, when they did that, they had to have a complete response to the eligibility rejection if it remained. So if their amendments to claims did not overcome that initial rejection that the examiner put them on notice about, they had to respond to that in their response after final or in their appeal. And the examiner handling the application was required to address all of their arguments that they put in that response. So, and in those cases, if the examiner had noticed when they were going through the responses and reviewing the claims of the case, if applicants' amendments did overcome the 101 rejections, the subject matter eligibility rejections, the examiner would just allow the application. I just want to be clear about that. That was one of the great opportunities under this pilot, that they were able to do that as well. So with that, let me turn it over to Dan so he can talk about some of the data with respect to and some of the things that happened with the applications that we saw when reviewed.
Thanks, Brian. We evaluated the pilot in a few different ways. We looked at applicant participation as sort of an indicator of interest. We got examiner opinions on the pilot in surveys and focus sessions, and we looked at prosecution history of applications examined under the pilot. So with regard to participation, we had around 600 examiners volunteer to be in the pilot. They were all primary examiners. This was restricted to only primary examiners. And not surprisingly, they were concentrated in areas that see eligibility issues fairly frequently. So the distribution of examiners and the invitations sent aligned pretty well with how frequently office actions in that technology area include a 101 rejection. The volunteers sent out 726 invitations to participate in the pilot. This graphic shows applicant engagement by technology center based on the percentage of invitations that were accepted. Overall, the acceptance rate was 28%. That did vary among the technology centers. The largest number of invitations were sent from Technology Center 3600. That's the business methods area, and 2100. That's the AI database area. And those areas also had a relatively high acceptance rate. So in those areas, interest in the pilot was relatively high. TC 1700 had a low number of invitations and none of those were accepted. That's not too surprising. It's consistent with the fact that eligibility issues are relatively rare in 1700. In other parts of the office, acceptance rates were generally less than 25%. And just so you know what we're talking, we've got this laid out, identifying the technology center. Some of you may not be familiar with the technologies examined in each of these technology centers. So in 1600, the pilot cases were mostly in bioinformatics, diagnostics, and natural products. In 1700, the pilot cases were mostly in chemical apparatus and purification. 2100 was mostly AI, database and file management. 2400 was cryptography and computer networks. 2600 was communications. 2800 was printing, measuring, testing, and optics. 3600 was business methods, and 3700, most of the pilot cases came from amusement, education, and medical devices. Next slide, please. Okay, so this shows some survey results. So we asked examiners for their perception of how prosecution went in each of the pilot applications that they examined. So to do that, when an application reached an allowance, abandonment, or RCE, the examiner was invited to complete a survey specifically directed to prosecution in that application. So the surveys were application specific, and we gave examiners time to review the prosecution history of the application so that their answers would be accurate with respect to the specific application. We sent 190 survey requests, and 167 surveys were completed. There were 20 questions in the survey. I'll just hit on a couple of highlights. Of course, as Brian said, one of the things that we wanted to understand was whether responses would overcome the eligibility rejection, even though the response wasn't specifically directed to eligibility. So overall, this is just looking at the response to the first action and whether the eligibility rejections were overcome. Overall, the applicant response to the first action overcame the rejection in 22% of pilot cases. At the TC level, that was as high as 56% in 2600. The communications area, although the number of cases in that area was relatively small. And then it was as low as 8% in 3600, the business methods area. In other eligibility hotspots like bioinformatics in 1600 or the AI area in 2100, the rate was around 25%. So we did see that eligibility rejections were overcome to some extent in all areas, but not a significant degree in the areas where it's needed most, for example, in the AI and business methods areas. Next slide, please. Okay, so we also wanted to see if DESMR had an impact on prosecution efficiency. So to do that, we compared prosecution histories in DESMR applications to prosecution and control applications. And for the control, we used applications that qualified for the pilot and got a first action during the invitation period. But they weren't in the pilot either because the examiner didn't include an invitation in the first action or because the applicant didn't accept the invitation. And the findings in this slide are based on the prosecution history at 18 months after the end of the invitation period. So the invitation period closed in July of 22. 18 months later, we looked at the prosecution history. That gave us enough time for all the pilot applications to finish at least one round of prosecution. But some of those applications were still pending after an appeal or an RCE. We did refresh the data fairly recently, and the findings were consistent with what we saw at 18 months. And what we found was that as compared with controls, a larger percentage of DESMR applications had still not reached the final disposal at 18 months. 25% of DESMR applications hadn't reached a terminal allowance or abandonment or hadn't gone to appeal, as compared with 16% of controls. And consistent with that, we found that prosecution of DESMR applications was more likely to include at least one RCE. And looking at applications that did get to a terminal disposal and allowance or abandonment, we found that it took on average more office actions to get to that abandonment or allowance in a DESMR case than in a control case. So on average, it took 2.7 office actions to get to an allowance in a pilot case, as compared with 2.2 office actions in a control application. So overall, we didn't see any evidence of an efficiency gain in the DESMR applications. Next slide. So this is showing results from another one of the survey questions. Examiners were asked what impact deferring eligibility had on several considerations in the case that the survey was directed to. Generally speaking, for most of these considerations, examiners felt that DESMR didn't have an impact, positive or negative, in the majority of cases. And that was especially true for evaluation of non-eligibility issues. In almost 80% of cases, examiners said that there was no impact on examination of issues not related to eligibility. On the other hand, when examiners thought that DESMR did have an impact, just generally, it was typically favorable. So if there was a perceived impact, examiners more often said that it was positive rather than negative. Next slide. Okay, then finally, we invited a subset of examiner volunteers to participate in focus sessions. We did the focus sessions in November of 2023, so about 16 months after the end of the invitation phase. And the purpose of the focus session was to get a broader view of the examiner experience with the pilot. So where the survey was specifically directed to prosecution in a single application, the focus session questions were more broad, and examiners were asked to consider the pilot more generally. In the focus sessions, some examiners told us the pilot did reduce their workload, and that allowed them to focus on other issues. We heard that mostly from examiners working in areas where there was a lot of prior art. So maybe the 101 issues was more of a distraction in that area. On the other hand, examiners did raise concerns about not having the applicant fully engaged in prosecuting eligibility, including that it could make prosecution less efficient by leaving loose ends that could have been addressed earlier. It could reduce clarity of the record unless the examiner put in extra effort to keep the record clear. And it could complicate after final practice by bringing in new considerations after the examiner had already done a final rejection. Also, examiners said that the atypical prosecution caused confusion in some cases. The pilot required special forms in arguments presented certain times and not in others. In at least some cases, that confused the applicant and put additional burden on the examiner to keep things on track. The next slide. Okay, so in summary, we did see that in several DESMR applications, the 101 rejection was overcome without the applicant having to respond directly to that rejection. However, that was more the exception. In the majority of cases, the 101 rejection wasn't overcome until the applicant responded to the rejection. We also didn't see evidence in the prosecution histories to suggest that deferring eligibility would improve prosecution efficiency. And although examiners did like some things about DESMR, especially the time savings of not answering arguments, they also identified drawbacks to deferring eligibility, including potential impacts on prosecution efficiency and clarity of the record. And so I think that ends our presentation. I guess I hand it back to Sean for questions now.
Thank you, and thank you to Tammy and Brian as well for being a part of today's program. At this point, we're going to transition to our question and answer section. Again, there were questions submitted in advance, but if you have questions now, you can still submit those while we're here at USPTO Hour at uspto.gov. So with that, let me take a look at what we've already received. Here's one to get started. Can you provide an update on the USPTO nominee, John Squires?
The Senate Judiciary Committee held a vote on Mr. Squires, and he was reported out favorably, 20-2. So now he has moved to the full Senate floor where he awaits further consideration.
All right, thank you so much for that. Let's see, what else do we have here? So how common are eligibility rejections?
Eligibility rejections are one of the least common rejections that we make. Currently, the eligibility rejection rate is right around 10%. So it's definitely not a common rejection, especially when you consider your prior art rejections are, you see rates of 60, 70%.
Were there any public comments on this pilot program?
Yes, we actually, when we issued the Federal Register notice, we opened it up for people to comment, and we received a few comments. There were not a lot of comments, but we did receive some public comments, and we've left that open and have asked over the course of the pilot, or have provided the opportunity for people over the course of the pilot to come in and provide us with additional comments based on their experience. I don't know that we've really received any as of late.
Can you speak to maybe why you limited the pilot to examiner and applicant volunteers?
How about if I turn that over to Dan, since it has to do with the examiners?
Brian kind of touched on this. The prosecution of these applications was atypical. So with regard to examiners, they have strict performance requirements. And there were aspects of the pilot that could complicate prosecution, especially after final rejection. So we weren't comfortable requiring examiners to participate in a pilot that could impact their performance. So we sought volunteers, but like I said, we did get, we were careful to look to see how representative our sample was, and the way that we did get sort of an enthusiastic response from examiners, and they were distributed in a way that we felt we got it comfortable. We felt comfortable that we got a good sample of examiners. With regard to applicants, we weren't comfortable sending an application through a non-standard prosecution path without the consent of that applicant, having that on the record.
Thanks, Dan. For those questions that I see that are coming in regarding presentation slides and recordings, those things will be made available online in the near future. Let's see, what else do we have? What do you mean specifically by technical drafting assistance?
So technical drafting assistance essentially means that the USPTO provides a drafting service. We review and we provide technical assistance on statutory drafting to Congress, and with the idea that helping ensure that the proposed legislation is consistent with our regulatory and our existing statutory framework. And at the same time, it also helps educate congressional staff about our statutory and regulatory framework. And the most important thing to remember about technical drafting assistance is that it is in no means a commitment on the position of the administration on that specific piece of legislation. So again, it is very much so, as it says, meant to assist Congress in drafting the legislation.
All right, thank you so much. Let's see. Some questions from the chat that are coming in. When applicants still had to respond to 101 rejections, how often were those objections ultimately overcome?
I don't have data to that. Dan, do you by any chance know?
That's actually something so the timing of our surveys, we got our used surveys to get at the prosecution. The timing of that didn't give us a good window into the full prosecution. Actually, what we're working on now is going back, now that we've got over 95% of applications have reached their final disposal. We're going back to look at the prosecution histories longer term to answer that kind of question.
The process that Dan's talking about is also a little labor intensive because we're going through the applications by hand. So we have to look at them. We don't have an automated way to go through them.
Thank you both for that. Let's see. What are the next steps with respect to taking into account the conclusions of the DSMR pilot program?
I'll ask Dan also for his thoughts on this, but I think that we just talked about it, to be honest with you.
Okay.
It's looking through this data, going through it, and seeing if there's anything that we can take from that we haven't yet. So Dan, do you agree? Do you have other thoughts?
Yeah, the only thing that I'll add is that we're still, now that we're showing the results, we'd still like to get input from stakeholders and the public. And so you can send, I want to put a plug in for sending comments on the pilot to the USPTO Hour box. We will take those comments. So we're looking at that as well. What the public view on this is.
Thank you both for that. That box is USPTO Hour, HOUR, at uspto.gov. Let's see. Why was the pilot program designed such that the rejection was included in the first action?
That was, we felt we had to include the rejection in the first action to put applicant on notice of what the rejection was, what the issues were, also to provide clarity for appeal. I know that was one of the issues that we were working with as we were trying to develop the pilot. And this way, we also met what we thought was the requirements on the office to give notice to applicants. So, Dan, do you have anything? I don't know if there's anything else you want to add to that. That's just my recollection of it.
Yeah, another concern that we had was that it could be that we didn't want to surprise applicants late in prosecution with a rejection that may have made a difference in how they approach the prosecution of that application. So we felt like they needed to be on notice that this was a concern.
Were applicants able to discuss the 101 in examiner interviews, even if it wasn't responded to until later?
Yeah, they could. It would have been. Yeah, we don't know. We didn't have any way to really know whether it was, but that's something that we might find in interview summaries through this labor-intensive process that we mentioned earlier.
Can you clarify what the objective was of the Dismer pilot? Was it to reduce the number of 101 rejections?
No. And in fact, I will say, just to be clear, in the letter that we received from the two senators, they reiterated a number of times that this was nothing to in any way reduce the number of rejections in the sense of watering down the enforcement of 101 and the positions the office takes with respect to 101. So we did not move forward with anything like that in mind. We were just trying to do, as we said, this sequenced examination in some way so that we could make some determinations as to whether or not rejections and responses to rejections in the art rejections were those amendments maybe overcame the 101 issues that were present in the claims upon filing of those claims. So that was the focus of it.
The letters that you're referencing by senators, where can those letters be found?
If you look for Dismer on our website, there are a number of links that you can follow, and one of those links is the letter it's a combined letter from the two senators.
All right, so uspto.gov and do a search for Dismer.
Yep. You'll find the Federal Register notice at that site. You'll find a lot of information. If you're interested in Dismer, I would strongly recommend you go to that site. There's a lot of information available to you if you go there.
Okay, thank you. Any other questions? Again, USPTO Hour at uspto.gov. For those who are submitting questions that are a little bit outside of the scope of today's program, don't worry. Trademark questions, PTAB questions, those type of questions, we will forward those along to our colleagues in those respective business units so that they can be addressed either at a future iteration of USPTO Hour or independently. So with that, I want to say thank you again to Tammy, Brian, Dan, the entire team that makes USPTO Hour happen, here with DMS, OCCO, etc. The OPSI staff as well. Again, thank you for joining us today. A survey will be sent out after this. We appreciate any and all feedback. We take that into account to improve upon the event series. You can also still email questions that you may think of after the fact to that same email address, usptohour at uspto.gov. There were a fair amount of questions about the slides and the recording being made available. Those things will be posted to the site once they have gone through the proper channels. And you can, similarly to Brian's response about Dismer, you can do a search for USPTO Hour on our website, and it should take you to the event page, and that is where those things will be located. So with that, thank you for taking time out of your day to join us. I hope you have a great rest of the day and rest of the week, and we'll see you soon, either online or in person. Thank you.